I think the second point that you want to have is what's the effect, and she hinted at this, but I think I want to make it much more explicit, is that when you start ratting on one of these kinds of conspiracies, what you're doing is you're increasing the probability of the conviction not of one other person, but of n other people. So if it turns out that the sanctions that you happen to lose with respect to one person are, say, 50%, but you manage to haul in at very high sanctions another 100%, another 20 or 30 or 40 people, the leverage effect that you get by getting maximal sanctions against the other will start very quickly to dwarf the diminishing effects that you have in the one case, which suggests that these characters are doing well. The third feature is about the fraud kind of situation and what happens there. And although she didn't mention, I think this is the way that I would handle that problem. You put in one of these things as a proffer, something which is very juicy, and the government starts to give you this evidence, and then they work their way around through the case and they discover, okay, that this is not, in fact, the accurate information. What happens is you bring ex post sanctions with respect to perjury on that particular element. So if you put all of these things together, I think that what happens is that the great contribution that she makes to this paper is to show us that even if you have a more complicated model, this is not a kind of a process that you should be determined on balance to upset, that rather to the opposite, it seems to work fairly well. So I'm on schedule so far, more or less. Okay, now we go to the third paper, and that's Jason's paper and so forth. And here we are now switching to the netherworld of constitutional law. And in effect, what happens is it's kind of an interesting, it seems as though we have a positron and an electron. We have one fellow who's developed a paper whose great purpose is to explain how it is that state courts can deal with the federal law. And then Jonathan comes up with a paper which says, you know what, I really am talking about an equal and opposite proposition of why it's perfectly appropriate for the federal courts to take on the state law. And I'm sitting there, and I feel like the rabbi who hears two inconsistent stories and says, you're right. The other guy says, but he disagrees with me. He can't be right. He said, you're right too. And the third guy says, how could you agree with two guys who disagree with each other? And he says, you're right too. I mean, so everybody turns out to be right. And maybe that's wrong, or maybe it's right, but at least it's worthy of some kind of comment on it. But let me sort of indicate to you why it is in these situations that I'm actually a little bit more of a traditional stick-in-the-mud conservative than either of our two learned constitutional lawyers. And starting with Jason's point, I think one of the things and instructive situations that was not mentioned in his particular paper, which lay at the heart of Martin and Hunter's lessee, was the question of whether or not you would get inconsistent types of enforcement such that you had a state court which went in one direction and a federal court that went off in the other direction, so that there would be real tension. And if you remember Story, who clearly misread the constitutionality of Section 25 of the Judiciary Act. I mean, I don't think that's wrong. I'm pretty sure that it's right. I think there's absolutely nothing whatsoever in the Constitution as drafted which allows you to have a federal review of a state decision which denies a federal constitutional claim. The way in which they thought to handle this was woefully inadequate, but they really thought that that portion of the Supremacy Clause, which says that the judges in every state shall be bound by the Constitution, was what they thought the structural check was, rather than having explicit review by the United States Supreme Court. I don't like this particular accommodation, but it's actually much more consistent with the sort of dual model of sovereignty that existed at the time. And it's also, I think, consistent with the somewhat slot machine theory of justice, what's developed at that time, in which squaring one document with another document was thought to be the kind of thing which could be done with a level of precision, which might be true on questions like original jurisdiction, but are never going to be true on questions like what's a justification in the Bill of Rights or something of the sort. So what happens is, I think in order to make this thesis go, the real question you want to ask is whether or not when these state courts are going to come and intervene in this situation, it's going to give yourself a challenge to federal sovereignty, which was the sort of thing that Justice Story was so worried about. And what's interesting about his talk, of course, is that every illustration that he gives essentially deviates from that particular proposition and kind of is one which says, you know, if we want to have a more vigorous enforcement with respect to federal rights at the state level, we can do so. Now, one of the sources of authority which he did not look at, which in fact is highly instructive, goes to the question of whether or not, if you want to bring a state tort action for personal injury, can you create, as a matter of state law, a private right of action under federal law, even though the federal statutes don't do it. So if you start looking at Court v. Ash, they're kind of reluctant about the enforcement of these things. But there are cases, I believe, in which it is generally held that a state court can decide to say, hey, this is just a source of law out there. As a matter of state law, we're going to create a private right of action under the federal law. And at that particular point, nobody is particularly troubled unless and until you start to think that there's going to be some kind of a preemption claim on the grounds that the federal statute has actually blocked the type of situation. And if you start looking at the other kinds of cases that he talked about, again, you know, sort of giving somewhat more expanded views of federal rights, I mean, in the most part, that's not going to be terribly troublesome because much of that stuff you could have done under state law anyhow. But here, too, I do think that there's at least one sort of issue that you have to worry about, Jason, and that's the question of what are you going to do with cases like the city of Bernie, where, in effect, what happens is you get this dreadful, I'm going to editorialize, a decision in Smith which sort of indicates that the Free Exercise Clause and the Establishment Clause are both sort of bland versions of an Equal Protection Clause, and everybody from the Civil Liberties Union to the Christian Union decide that this is absolutely crazy, and what they decide to do is to stop that. So which way do you want to go on that? I think, in effect, you're going to really have to think of whether or not that kind of reaction is there. Now, with respect to Jonathan, because I'm sort of running on time, he runs this in the opposite situation, and a lot of this depends upon what you think to be the appropriate mode of constitutional interpretation. Jonathan clerked for Mike Ludick and for Nino Scalia. The courses he took from me were patent law, I guess, and First Amendment law, if I'm not mistaken. I'm not known as a great passionate believer in judicial restraint, and so in some sense I think, hey, this is a really ingenious idea to get you into exactly the wrong place when you would want to be. I mean, I can understand why it is in many cases that federal courts might wish to dump discussions of controversial issues, and they already have other avoidance devices like not taking certiorari, for example, which would allow them to do that. But the question is whether or not you're going to create an institutional imbalance of one sort or another if, in fact, you allow them to use a Murdoch-type argument or reverse that so as to take on a state law. Let me just sort of take one case and sort of illustrate the problem. And that case is the case of Dale against the Boy Scouts, on which I actually wrote an article. I don't know if you know about it, Jonathan.
Cited.
What? It's duly cited. Yeah, I figured as much. In 2000, it has to be cited, therefore, with some disapproval. Because my own view about this is that when you start looking at the state stuff on the definition of what's the place of public accommodation, Jonathan is clearly right, these guys are stretching. I mean, thou shalt not tell the truth is, in discrimination cases, often a very important judicial postulate. But let's suppose that we do it exactly his way. And what we do is we say, no, you're reading this thing much too broadly. You got two problems. One is this may be the law of the case, but the next case that comes up inside a New Jersey court, which of the two readings are going to use? The Supreme Court reading on state law or the state court reading on state law? And if it's not the law of the case, I don't want to get yourself into trouble, and God forbid you should then take that second case and put it in federal court in a kind of a, where you get jurisdiction, say, on an ancillary claim, and you have to worry about which of the two readings it's involved. And the second thing I think that what happens is that if you do this sort of stuff, there's always the risk of statutory modification, which makes clearer and more dreadful the outcome that they have, and then in effect forces you back into exactly the same constitutional claim. My view about it is there is no answer to the question of do we believe in judicial activism or judicial restraint except this one. Either you get the cases right or there's going to be catastrophe no matter what you do. And so I spend most of my time trying to think of what's the right kind of outcome of a case rather than trying to think about whether or not there is an avoidance mechanism that's there. Sooner or later this case will start to come back to haunt and to bite you, and what you have to do is to think your way through this. And of course the great difficulty in this particular area is that freedom of association is a dirty word with respect to economic arrangements and an appropriate word with respect to expressive arrangements and a sacred word with respect to intimate arrangements. What happens is we have a proliferation of too many Supreme Court categories, each with its own weight, which is where the mechanism goes. And so my preference on this stuff has always been to sort of run right at the federal question, but to try to get the normative theory right.